Moving to the next part, as we understand, FDIS has introduced screening procedures for non-EU investors with a narrow objective, defending security and public order. A new screening procedure is to be introduced as well, adding a standalone screening process on foreign investors to assess the potential distortions in the internal market, service and financial flows. Its scope is much broader and the mechanics of its implementation remain to be determined. What to expect after the new compliance requirements, how they interact with the anti-avoidance guidelines on investment, how much leeway is left to the national authorities. Should we expect any influence on Cyprus structures? To discuss this, we welcome Professor Nikitas Hadjimichail and Dr. Eleni Apostolidou. And before that, a short presentation of the debaters. Mr. Nikitas Hadjimichail, SJD, Doctor of Judicial Schedule in Harvard, Professor of Commercial Law, Private International Law and Comparative Law, Director of the Dispute Resolution Laboratory. He has been a member of the Athens Bar since 1998 and an accredited mediator with the Center for Effective Dispute Resolution since 2014, with practical experience principally in international commerce, arbitration, and business transactions. He has also worked as an advisor on legal and institutional affairs to the Green Minister on the Aegean and Island policy between 2005 and 2006, and he's at the Department of Law in the University of Cyprus. Dr. Eleni Apostolidou, with a PhD in business taxation from Sorbonne and an MSc in public administration, is an assistant professor of CIM in Cyprus and program director of the MSc in international taxation and financial law. In the past, she was an assistant professor at several French universities and led research activities and workshops in Austria, where the core of her activity was focused on European and international taxation law. She has been an author of publication on various issues that cover public finance and fiscal policy. She's a member of the French and Cyprus Bar Association, a certified mediator on civil and commercial disputes, and an expert on legal and economic development for various think tanks. And I will now bring them forth so that they can start discussing on this issue.
Good evening, everybody. Thank you for having joined this research event from our Master in Financial Law International Taxation. As Professor Bovis has lengthily explained the new screening procedure that pursues an objective to monitor investments that could trigger any issues of public order and security. My presentation is also the one of Nikitas. Will focus on the next step that is being prepared. So we'll do some of prospective law based on the Commission's white paper, levying the playing field as regards foreign subsidies. How this interlinks with the FDI screening? Well, where the FDI screening targets foreign investors trying to acquire assets in the EU, where those investors have, besides that, benefited from subsidies from their governments. Well, this screening, the screening related to foreign subsidies, shall also be triggered and work in parallel, side by side with the one we have just seen. Audit subsidies raises a special interest to tax people and advisors because, as we already know from EU state aids, subsidies can be tax incentives. What shall we understand by subsidies? Has been decided in the EU communication on new requirements against tax avoidance in financing and investment operations from 2018. So what you will briefly hear about this white paper on the new screening process, that at the present stage is only under public discussion, will be very close to its model to what we've seen under the FDI screening. So we screen inward investment of non-EU investors that seek to acquire EU targets, but this time in all sectors and markets, as far as we detect that they have been subsidized and that as entities, and that this could and may concern the acquisition of an EU target in the sector of goods, services, or investments, and cause distortion to the EU market. Who's a foreign investor? He doesn't need to be an undertaking that has made use of the establishment in the EU, so as incorporated a company. It can just be an undertaking that is active, has business units here, or could be established in the EU, or linked to an entity that has no active undertakings in the EU, and is not established in the EU, but is an affiliated entity and has received the subsidies. So as the linking rules for the allocation of subsidy and the relation between the two entities, the undertaking active in the EU and the one established abroad are still to be further detailed at the next process of the drafting of this legal instrument. Which undertakings can be the target one? We are at this stage exploring the thresholds. It could be a qualitative threshold referring to all assets likely to generate significant EU turnover in the future. So as we need to do some projections and calculations as it refers not to the past, but to the future turnover, and or quantitative thresholds with reference to the value of the transaction. This could be more easy to assert. And then quantitative thresholds of the acquired target that could amount at minimum 100 million. This is a far, I would say, low threshold. When it comes to the acquisition, not much is known at this stage. It could be directly or indirectly. Taking control of an undertaking, how much control? Well, we don't, it seems that a material influence could be enough. So as having minority rights, not even controlling minority rights, but significant would be good enough. The percentages of the acquisition of shares of interest in the target entities are not defined yet. All this can be debated under the scope of the freedom of capital and portfolio investments, and Nikitas and the other participants could bring in some arguments and fit our thinking of that. How much subsidy? Well, 200,000 euro within the 3 years, the previous 3 years. So the amount of subsidy is also at this stage not low enough to affect an important, significant number of transactions. Who is to set the threshold? It could be the member states. It depends how much leverage they want to have within this mechanism. And what is also discussed is to have a ratio about this, to evaluate the amount, make use of a ratio of the value of acquisition, so as the price compared to the financial contribution of the foreign authority, the subsidy, or a minimum numerical threshold. Well, for proceeding with the screening, it seems that this would be on a case-by-case basis, and the size of the subsidy beyond triggering just the screening would be considered to evaluate its distortive effect, the situation of the beneficiary, the size of the investor of the target company, the situation they have on the market, degree of concentration, excess capacity of investor, privileged access to the market. So all these are relevant to the characteristics of the market itself. The level of activity, here we expect to have some ratio of the target entity compared to the global entity's level of activity to see how significant it is within that group. And the question of the public order is reintroduced here under the principle of the balancing and weighting these factors to the EU interest test. So even if the criteria get to be satisfied and the transaction seems not to qualify under the screening procedure, if the EU interest test is satisfied, then we will understand that the transaction goes for the EU interest and it should be approved and validated. As to the procedure, just in 2 words, it follows more or less what we have seen under the FDI. So we have an ex-ante notification procedure. If we fail to disclose in a self-assessment the information, we risk an ex officio investigation. Under the FDI, the standstill period for the parties to conclude and finalize the transaction is 35 days, if I'm not wrong. Here, the length is to be determined yet. The authorities could be member state, the commission, and a cooperative mechanism for the exchange of information between member states. But all this is yet to be better shaped and defined. What we understand is that the Commission would like to keep the control of the in-depth investigation, information to disclose. Some of them were expected, like the ownership, governments, information on financing, the turnover of the target company or of the investor. Others are more difficult to provide. For example, the alternative prospective acquirers. So as if this transaction is not concluded, who would have been a prospective alternative acquirer? That would be a bit more difficult to disclose. Third countries, authorities' contribution, that's the objective pursuit. So we understand why this information is required. What is changes apart the scope that is much broader? What changes here compared to the FDI is that the Commission's view is this time to be binding on the member states, and that the redressive measures not only limit to the prohibition of the conclusion of the target transaction, so of the acquisition or investment, but it could be accompanied by fines to be for the EU or for the benefit of the member state in which the operation was to be placed, an obligation to license the rights we were discussing before, to other competitors, and prohibition of some market contacts. Also, there is a mention of disinvestment in the market in the original paper that doesn't show in the slide. So a subsidy from a foreign government as such is not a difficult question to deal with. But when it comes to consider that fiscal incentives, such as setting off of operating losses and debt forgivenesses or rescheduling, so all tax amnesties, may be foreign government subsidy. It's true that this is not that much unusual for companies to participate in this kind of schemes. And it's not what we think about first when we discuss fiscal incentives. And preferential tax treatments, such as tax credits, are also highlighted. This in Cyprus would be the, for example, the intellectual property box, the notional interest boxes that are preferential tax regimes, although they are not harmful, and the harmfulness is not addressed. Beyond the communication that does not link to what is already known as fiscal incentives under the definition of subsidy for the EU purposes in the area of EU subsides, we do have a communication that I expect to be at some point linked to this new screening. Why I'm saying that? Because when we do screening and we appreciate whether investors have benefited EU subsides to block the transaction, we look into this communication, and the definition is common in many instruments, like the EFSD, ELM decision, EFSI regulation, and the financial regulation itself. There, we learn something more about the minimum standard understanding on what tax avoidance would be, that it's even more aggressive as a term than tax incentive, that I understand as a very soft version of tax avoidance. And there we see that all kind of financial flows that are expected to not to make use of offshore jurisdictions like the one we have on the EU list of non-cooperative jurisdictions. They expect that the revenue stream is subject to effective taxation, so that it's not just the entity that is subject to tax, but the precise financial flow. Then we look for more transparency for debt financing, securitization, and financing via funds. And this covers both investment funds that are treated as corporations and equity investment funds that are transparent entities and could be also foundations. And the information asked about the BO is quite what we know under the anti-money laundering directive. So natural persons with controlling ownership of 25%, direct or indirect. And the objective is to take it down to 10% minimum. By default, we need to name the official senior manager. So as we don't know how much the Cyprus authorities will be involved into this, as the definitions, thresholds, and standstill period are still to be shaped, also the sanctions, I would invite all of us to think about this, consider it, and if we have some clever and smart comments, to share them with the Commission. And I also expect that the national experiences from the FDI screening process could to some extent be transferable to this screening too. That's all from me. Thank you for your attention, and I hope I didn't tire you too much.